Justice Indu Malhotra, first woman to be elevated directly from the bar and the seventh woman judge to be appointed at the Supreme Court. Hello and welcome to Law Kanya. You already know the topic of today's discussion, that is important judgments by Justice Indu Malhotra. But before going into that, let us have a brief information about my inspiration, Justice Indu Malhotra, who is to retire today. Justice Malhotra was appointed as a Supreme Court judge on April 27, 2018. She also holds the distinction of being the second woman to ever be designated a senior advocate by the Supreme Court. Prior to becoming a lawyer, Justice Malhotra completed her LLB in 1982 from Campus Law Center, Faculty of Law, Delhi University, and also taught as a political science lecturer in the same. She joined legal profession in 1983 and in 1988 secured first position in Advocate on Record examination. Over the 3 years as Supreme Court judge, Justice Indu Malhotra has delivered a series of remarkable judgments ranging over varied streams of law, that is, from criminal to commercial. Let us get started. The first case, while disposing of an application by the CBI seeking modification of time limit prescribed in an earlier judgment, a bench of Justices A.K. Goel and Indu Malhotra observed that speedy investigation is recognized as a part of fundamental right of fair procedure under Article 21 of the Constitution, and that no investigating agency can take unduly long time in completing the investigation. This bench went on to record that there was a clear need for timelines for completing investigation and for having an in-house oversight mechanism, wherein accountability for adhering to laid down timelines should be fixed at different levels in the hierarchy. Further, it was held that inordinate delay may be taken as presumptive proof of prejudice, particularly when accused is in custody, so that prosecution does not become persecution. This was in the case of Dilwar v. State of Haryana and others, dated 1st July 2018. In another case upholding a Delhi High Court judgment which held that moratorium order under the Insolvency and Bankruptcy Code will apply to the order of the Income Tax Appellate Tribunal. In this, a bench of comprising Justice R.F. Nariman and Indu Malhotra observed that the Insolvency and Bankruptcy Code will override anything inconsistent contained in any other enactment, including the Income Tax Act. Given Section 238 of the Insolvency and Bankruptcy Code 2016, it is obvious that the court will override anything inconsistent contained in any other enactment, including the Income Tax Act. This was held in the case of Commissioner of Income Tax versus Monnet Ispat and Energy Limited, dated 10th August 2018. In yet another case in which the bench of Justice R.F. Nariman and Indu Malhotra held that an application for setting aside an arbitral award will not ordinarily require anything beyond that record that was before the arbitrator. The court did, however, go on to note that if there were matters not contained in such record and were relevant to the determination of issues arising under Section 34, subsection 2, clause A, they could be brought to notice of the court by way of affidavits filed by both the parties. In this, Malhotra held that cross-examination of persons swearing to the affidavit should not be allowed unless absolutely necessary, as the truth will emerge on the reading of the affidavits filed by both the parties. Also, the bench took into account that the enactment of the Arbitration and Reconciliation Act as well as subsequent amendments was for the speedy resolution of the arbitral disputes. Therefore, if issues were to be framed and oral evidence was to be taken in a summary proceeding under Section 34, this subject could be defeated. All this was held in the case of Imake Global Financial Services Limited versus Girdhar Sondi, which was dated 20th August 2018. Now, in this case of Anand son of Siddheshwar Durg versus Pratap San of Zamampana, Lamzane and others. In this case, the claimant is entitled to be compensated for his inability to lead a full life and enjoy those things and amenities which he would have enjoyed but for the injuries. This was observed by the bench of Justice R.F. Nariman and Indu Malhotra as they enhanced the compensation awarded to a man by the Motor Accidents Claims Tribunal by almost 3 times, and held that in cases of motor accidents leading to injuries and disablements, it is well settled principle that a person must not only be compensated for his physical injury but also for the non-pecuniary losses which he has suffered due to the injury. The claimant is entitled to be compensated for his inability to lead a full life and enjoy those things and amenities which he would have enjoyed but for the injuries. The purpose of the compensation under the Motor Vehicles Act is to fully and adequately restore the aggrieved to the position prior to the accident. This was stated by the Justice Indu Malhotra. And in this, a landmark judgment decriminalizing homosexuality, Justice Indu Malhotra in her separate judgment observed that the history owes an apology to the members of the LGBTQIA community and their families for the delay in providing redressal for the ignominy and ostracism that they had suffered for centuries. A subjective notion of public or societal morality which discriminates against LGBT persons and subjects them to criminal sanctions simply on the basis of an innate characteristics runs counter to the concept of constitutional morality and cannot form the basis of a legitimate state interest. Justice Malhotra further held that Section 377 was too open-ended and provided scope for misuse against members of the community, and that by curtailing personal liberty of these persons to engage in voluntary sexual relationship with a partner of their choice in a safe and dignified environment was violative of Article 21. This was the famous case of Navtej Singh Johar and others versus Union of India, which was through the Secretary, Minister of Law and Justice. This was dated 6 September 2018. Also, in this next case, which is a landmark in itself, striking down the 158-year-old adultery law under Section 497 of the Indian Penal Code, Justice Indu Malhotra of a 5-judge bench recorded that the section failed to consider both men and women as equally autonomous individuals in society. A law which deprives a woman of the right to prosecute is not gender neutral. Under Section 497, the wife of the adulterous male cannot prosecute her husband for material infidelity. This provision is therefore ex facie discriminatory against women and violative of Article 14. Section 497 as it stands today cannot hide in the shadows against the discerning light of Article 14, which irradiates anything which is unreasonable, discriminatory or arbitrary. This was remarked by Justice Malhotra. Also, she went on to note that proceeding on the basis in a consensual sexual relationship, an adulteress who had knowingly and voluntarily entered into sexual relationship with another married man was the victim and the male offender was the seducer was unrealistic. The time when wives were invisible to law and lived in the shadows of their husbands has gone since long by. A legislation that perpetuates such stereotypes in relationship and institutionalizes discrimination is a clear violation of the fundamental rights guaranteed by Part 3 of the Constitution. There is no justification for continuance of Section 497 of IPC as framed in 1860 to remain on the statute book. We all know the name of this case, Joseph Shine versus Union of India, dated 27 September 2018. In this case, Justice Indu Malhotra, the lone woman in the Constitution bench which had heard the Sabrimala matter pertaining to entry of women of all age groups in temple, dissented against the entry while opining that in issues of deep religious sentiments, the court should ordinarily not interfere. Also, stating that entertaining PILs challenging religious practices in pluralistic society could cause serious damage to the constitutional and secular fabric of the country. All this was noted by Justice Malhotra, and she also cautioned permitting PILs in religious matters would open the floodgates to interpolers to question religious beliefs and practices. Even the petitioner is not a believer of a particular religion or a worshipper of the particular shrine. The perils are even grave for religious minorities. If such petitions are entertained, she further observed that the court had the constitutional duty to harmonize the rights of all persons, religions, and denominations of sect thereof to provide and harmonize the religion of all purpose to practice their religion according to their beliefs and practices. Judicial review of religious practices ought not to be undertaken, as the court cannot impose its morality or rationality with respect to the form of worship of a deity. Doing so would negate the freedom to practice one's religion according to one's faith and beliefs. It would amount to rationalizing religion, faith, and beliefs, which is outside the ken of courts. Justice Malhotra explained. This case was Indian Young Lawyer Association and others versus State of Kerala and others, dated 28 September 2018. In yet another case, reiterating that the grant of relief of specific performance is discretionary and equitable relief, the bench comprising Justice Abhay Manohar Sapre and Justice Indu Malhotra listed out the requirements to be answered in specific performance suit. First is whether there exists a valid and concluded contract between the parties for the sale or purchase of a sued property. And second, whether the plaintiff has been ready and willing to perform his part of contract, and whether he is still ready and willing to perform his part as mentioned in the contract. The third question which is to be looked is whether the plaintiff has in fact performed his part of the contract, and if so, how and to what extent and in what manner he has performed, and whether such performance was in conformity with the terms of the contract. The fourth question is whether it will be equitable to grant the relief of specific performance to the plaintiff against the defendant in relation to sued property, or it will cause any kind of hardships to the defendant. And if so, how and in what manner and the extent if such relief is eventually granted to the plaintiff. And the last question which is to be looked is whether the plaintiff is entitled to grant of any other alternative relief, namely refund, earnest money, etc., and if so, on what grounds. All these were to be put forward in the case of Kamal Kumar versus Premlata Joshi and others. In this case, Supreme Court bench of Justice UU Lalit and Indu Malhotra upheld an NCDRC order and observed that a hospital is vicariously liable for the acts of negligence committed by the doctors engaged or impaneled to provide medical care. Referring to Bolam test and other judgments on medical negligence, the court observed that the reasonable standard of care for a premature baby mandates screening and checking up for ROP. Further, it held that a medical profession should be alert to the hazards and risks in any professional tasks he undertakes to the extent that the other ordinarily competent members of the profession would be alert. He must bring to any professional tasks he undertakes reasonable skill that other ordinarily competent members of his profession would bring. This was held in the case of Maharaj Agrasen Hospital and others versus Master Rishabh Sharma and others, which was dated 16th December 2019. Now, we all know that right to property is a constitutional as well as a human right. This was held by the bench comprising Justices Indu Malhotra and Indira Banerjee. This was while allowing an appeal filed by Hari Krishna Mandir Trust in the matter of a land disputed with the Pune Municipal Corporation, and the bench observed that the right to property is still a constitutional and a human right. It was held that The right to property includes any proprietary or hereditary interest in the management of a religion endowment, as well as anything acquired by an inheritance. The right to property may not be a fundamental right any longer, but it is still a constitutional right under Article 300A and a human rights as observed by the court in Vimlaben Atalji Bhai Patel versus Vatsalben Ashok Bhai Patel and others. In view of the mandate of Article 300A of the Constitution of India, no person is to be deprived of his property save by the authority of law. The appellant trust cannot be deprived of its property save in accordance with the law. All this was held in the case of Hari Krishna Mandir Trust versus State of Maharashtra and others. Now, in yet another case, the Supreme Court held that there was no bar on granting anticipatory bail for an offence committed under the Muslim Protection of Rights on Marriage Act 2019, provided that the competent authority must hear the married Muslim woman who has made the complaint before granting anticipatory bail. The bench comprising of Justices D.Y. Chandrachud, Indu Malhotra and Indira Banerjee held that it would be at the discretion of the court to grant an ad interim relief to the accused during the pendency of anticipatory bail application. Having issued notice to the married Muslim woman, it was further observed that the relatives of the husband cannot be accused of an offence under the Act. On a preliminary analysis, it is clear that the appellant, as the mother-in-law of the second respondent, cannot be accused of the offence of pronouncement of triple talaq under the Act, and the offence can only be committed by a Muslim man. All this was held in the case of Rahana Jalal versus State of Kerala and another dated 30 December 2020. Now, in the case of Vikas Krishna Rao Gavali versus State of Maharashtra, the Supreme Court read down Section 12, Subsection 2, Clause C of the Maharashtra Zilla Parishads and the Panchayat Samitis Act of 1961, which provides that reservation of 27% of seats in Zilla Parishads and Panchayat Samitis, reservation in favor of OBCs in the concerned local bodies can be notified to the extent that it does not exceed aggregate 50% of the total seats reserved in favor of SCs, STs and OBCs taken together. The bench of Justices A.M. Khanvilkar, Indu Malhotra and Ajay Rastogi observed. This court also held that the rigid interpretation of the provision would be violative of the dictum laid by the Constitution in K. Krishnamurthy versus Union of India, which was 2010's case, and that the state legislations providing for reservations of seat in respect of OBCs must ensure that in no case the aggregate vertical reservation in respect of SC, STs and OBCs taken together should exceed 50% of the seats in the concerned local bodies. The provision in the form of Section 12 can be saved by reading it down to mean that reservation of OBCs in the concerned local bodies may be notified to the extent that it may and does not exceed 50% of the total seats reserved for SCs, STs and OBCs taken together. In other words, 27% occurring in Section 12 may be construed as to include reservation for OBCs up to 27%, but subject to outer limit of 50% in aggregate. This was held in the case of Vikas Krishna Rao Gavai versus State of Maharashtra. This was it for this video, and these were the important judgments in which Indu Malhotra was part. Thank you for watching and being part of this. Also, I'll put the link of my Telegram channel in which I'll share the updates of the latest judgments. Thank you for watching.